Good afternoon, everyone. Thank you for being here. Welcome to our special education legal clinic. I'm just going to give it one quick minute to let the attendees continue to log in, and then we will get started. I hope everyone is enjoying their nice April afternoon. Okay, I think we are good to get started. So, like I said, good afternoon for everyone who missed it. Welcome to our special education legal clinic. My name is Renee Stromsky, and I'm one of the special education attorneys with Apnor Weicker, which is a law firm for student and educator rights. This legal clinic is a collaboration between our firm, the Ohio Coalition for the Education of Children with Disabilities, OCECD, and today's presenters, Disability Rights Ohio. Each month on the third Monday, we host a 1 hour workshop on a special education or related legal topic. And after the workshop, we offer free 30-minute individual guidance sessions with an advocate or an attorney between 1 and 3 p.m. And you can sign up for those at our legal clinic website, which is www.lawyers4students.com/legal clinic. I can drop that in the chat in a second. And you can also register for next month's clinic, which is on May 18th. And it is actually going to be presented by Danielle Randolph, one of our special education advocates at AW. And it is going to be on applying information from your evaluation team report to the IEP. So last month, Lisa comes from the Ohio Association of County Boards of Developmental Disabilities, presented on services that are available through different county boards of developmental disabilities, including services and support where you may be eligible um, for a Medicaid waiver that allows individuals with developmental disabilities to receive services in their home or in the community. And a recording of that workshop and all prior sessions is available on our website. And building on that topic, today's workshop is titled When Waivers Are Denied, Your Options and Rights. And presenting our two attorneys from Disability Rights Ohio. We have Ginger Wilson and Shannon Baldwin. They will also be, in their presentation, they will be revisiting the eligibility criteria that we discussed last week. So this will be helpful whether or not you were able to attend last month's session too. There is a Q&A feature available in the Zoom. Please feel free to submit questions at any point during the presentation. I'm going to turn my camera off to let the spotlight be on Shannon and Ginger, but there will be some monitoring in the Q&A, and we will pause periodically to share your questions with Ginger and Shannon. So with all of that, I will turn it over to Shannon and Ginger. Thank you both for being here.
Absolutely. We're glad to be here. So I am Shannon Baldwin, and I am an attorney with Disability Rights Ohio. Disability Rights Ohio is Ohio's protection and advocacy agency for people with developmental disabilities.
You want me to go ahead now? Okay. Do you want me to go ahead and introduce myself?
Yes.
So I'm Ginger Virginia Wilson. I've been with Disability Rights Ohio for many years. I have been doing Medicaid waiver stuff for maybe since 2017. We get a lot of calls about it. We did think it was important to talk about the DD eligibility a little bit because it's kind of the barrier you need to get over in order to get to the Medicaid waiver. So I think Shannon's going to spend time talking mostly about the DD eligibility issues that we see, and then I'll talk about the DD waivers. Thank you.
Ready to go. Thank you. Yes, so we did want to touch upon this because it's all very confusing and overwhelming. So this will kind of give you some context of getting to the Medicaid DD waiver issue. So there are 88 counties in Ohio. Everyone has a county board of developmental disabilities. They can provide services for eligible kids and adults with developmental disabilities. And to access the services, you do need to apply for eligibility in the county where you live. So, who is eligible? Again, if you're in the county, if you have a qualifying developmental disability, it cannot be just a mental health diagnosis. And the disability has to manifest or show itself before 22 years old and likely to continue indefinitely. And there are also additional requirements depending on your age and how many substantial functional limitations you need to show in different areas. So for children under age 3, Ohio has a couple of programs that we're going to touch upon, and we have links in here so you can go to the website and learn more. So for eligible children under age 3, there is early intervention. So if you have a child under that age, you have concerns, you can see if they are eligible. And if they are, they can build a team to help meet your child's needs. And there's also the complex medical help program that if you do have a child with special healthcare needs under the age of 3, they can, and they're found eligible, they can put together a team to address your child's needs, work together, and they can also help with funding. For children 3 to 5 years old, the county board will verify the diagnoses with the doctor, assess whether the child has substantial developmental delay or diagnosed congenital or acquired condition, and determine if the delay or condition is likely to result in substantial functional limitations in the different areas in the future if they do not receive services. And also, if you have a child approaching 3 or in this age range, you can check with your school district because there are services that can be available for an eligible child, like special education preschool, and they can start addressing needs if appropriate. And that's part of the free and appropriate public education. So for people age 6 to adult, this is when we get into the um, Children's Ohio Eligibility Determination Instrument, and that's for 6 to 15-year-olds. And then there is the OEDI, the Ohio Eligibility Determination Instrument for people 16 and older. And there are different categories that they are looking at and assessing to see if there are substantial functional limitations in those areas. We have them listed here. There's mobility, self-care, self-direction, capacity for independent living, learning, and receptive and expressive language. There is for 16 and up, economic self-sufficiency is also assessed. And we have some examples in each category to give you an idea of what they're looking at and assessing. And we've also given you links so you can take a look at the COEDI and OEDI and get a feel for what they are assessing, what questions they're asking, what they're looking for.
If I can jump in for a second, just to
Yes.
say here, we really do recommend that you take a look at that before you do the assessment with your child. It gives you kind of a sense of the questions they're going to ask. And I think the next slide is going to give you some guidance that's also on DODD's website. And we would recommend you take a look at that as well, because it sometimes when you're answering these questions, for example, can they walk? And your child may be able to walk, but they might have a really hard time with it, or they can only walk short distances, or they can't walk by themselves out in the community, or they'll walk out in front of a car. So it's tempting to just answer, sure, they can walk. And that's why it's really important to look at these assessments and look at the guidance, because you want to think before you answer these questions so that you can be accurate and clear when you're giving them. Because if you say, yeah, he can walk, the county board might just take that, and then that will not be considered a substantial functional limitation, when actually your child may actually have some significant issues with mobility. And mobility in this circumstance is navigating your community. So it's not just can you walk, it's can you walk safely in the community, and a lot of different things. And all the categories kind of have those nuances that you ought to be aware of. So you're careful and thoughtful when you answer the questions when you're doing the assessment. So we included them because we think it's really important for people to take a look at that, so you kind of get a real sense of how the assessment goes, how it works, and what you should be telling the county board. I always tell everyone, this is not the time to talk about your child's successes and all the wonderful things they can do. This is the time to talk about your child's limitations, which is hard sometimes because we all want to say good things that our kid can do. This is not the time to do that. This is the time to really talk about those limitations and make sure that it's really clear to the county board what they are. Thank you, Sergeant.
No, great points, Ginger. Thank you. And so we've also given you links to the user guide and the life activity areas guide. These are really helpful. And just like Ginger was talking about, taking a look at these documents. And the life activity areas user guide, I think of it as a best practices for an assessor. It's not just a yes or no answer that should be considered. They should be diving in to find out more of the nuances of the needs that the individual may have. And these are very helpful if you do receive a denial, because they can help you form your arguments. So you go through the eligibility process and you receive a denial. So these are some of the rights that you have. You should be told why someone is denied, and hopefully you receive the denial in writing. If you receive it verbally, or you don't hear a word back, you do have the right to receive an answer. And if it is a denial, that date on that denial letter is important. We'll talk about this in a minute. If you want to appeal, you have the right to have an attorney, question staff, and examine the records. You should get a copy of the assessment answer sheet, and also gather additional documents that would help support eligibility. So if there is a denial and you want to have strategies for addressing them, we've touched upon those here. So you have the right to get the records, the answer sheet. Also, what can be helpful is the assessor may have taken notes. You have the right to receive those, and gather any documentation from providers that have dealt with your child, teachers, IEPs, any documentation that could help support the argument that your child has unmet needs.
And the reason we tell people to get the answer sheet is we hear it a lot. When people get the answer sheet, they're like, that's not what I told them, or I told them this and it's not on there. So it is really important to see how that was actually scored. You won't see that during the assessment, but it's really important if you get denied, so you can say, hey, that's not accurate. I told them this, but they didn't write that down, or they said no when they should have said yes, or vice versa. The assessment's kind of weird the way it's scored, but You can see all of that if you have the answer sheet. And as Shannon mentioned, also the notes. So sometimes having the notes has been helpful when you're challenging it because it's right in the notes what you told them, but they never transferred it over to the answer sheet to be considered in the scoring. A lot of times what people get is a denial letter that says you only have two areas and may or may not tell you what areas those are. They found substantial limitations. Well, you need to know that if you're going to appeal it. You need to know how they made that decision, what areas they're saying that your child doesn't have substantial limitations, so you can refute it and provide documentation and appeal that with with the facts basically. So it's really important to straight out ask for that answer sheet and any notes taken by any of the assessors. That gives you a much better idea of how they made that decision. And oftentimes people are like, that's not what I said, or
Mhm.
that didn't include a lot of what I already told them. So it's important.
So, further addressing strategies, as Ginger just touched upon, reviewing the answer sheet because you may not feel like it reflects what happened in the room, what the assessment answers were, and then what you do or do not disagree with, and what you're going to want to form arguments to refute. So, it will, there may be significant limitations found. There may not be. You want to see how much you have to argue. If you're close in one area of substantial functional limitations, that might be one that you want to go after. Maybe they didn't really capture the full picture of the person's needs. And you can get a feel for that as you go through the answer sheet and notes. This is where the user guides come in very handy because, again, the best practices of it's not always a simple answer. How could the assessor have asked more questions to give a bigger picture and a clearer picture of how a person would have a challenge in a certain circumstance? So the goal is to review the documentation and figure out what you disagree with and why the conclusion of the board was incorrect. So an example would be if an assessor asks a child, "Can you cross the street?" and the child says yes. That's not necessarily the full picture. It could be the thought of crossing the street. They could do it. They're running out in front of traffic. They're not waiting for a red light. It's extremely anxiety provoking. It takes them a half an hour to cross the street. You can give so much of a fuller picture of what the needs are and meet that category of substantial functional limitation by giving examples of what their needs are. If there's another issue where, can someone um, do laundry? Dig into that. How long does it take them? Do they know to put soap in the washer? They're just those everyday tasks that you can really think about how that person struggles and how long it takes them and the nuances of the tasks. You can
Just
also,
if I
oh, yes.
sorry, Shannon knows
No,
I do this all the
you're
time. Sorry.
good.
One thing I want to point out here is that as parents we tend to do things for our kids with disabilities without thinking about it. So we just get their clothes ready for them. So you need to approach all these questions with, can they do it independently? So I always give the example of the clothing. Yeah, they can get dressed, but what are they going to put on? Are they going to put on a bathing suit in the middle of winter? Do you have to remind them 40 times? So I think it's typical just to answer, yeah, they can get dressed, but you really have to think about before you answer those things about what you really do to help get that to happen properly. And there may be a whole lot of steps that you do that you just don't think about anymore because parents, we just need to get them out the door and get them dressed. But it is really important to think about those things and raise them when you're in this assessment, because otherwise, the county board's going to be like, oh, great, he can get dressed. Well, he might be able to get dressed, but he might go out in the middle of winter with a bathing suit on and no shoes, and so all of those things are really important, and you might not think of them originally, but when you're preparing for this assessment, I would really caution you to really think about those things. Can they do it independently? How much help do they actually need? Do they do it well? And Shannon will probably talk about some of those things, but I just, as you're going through all these, getting ready for these assessments, it's really important to, again, focus on what the limitations, what help they need. As a parent, we tend to give a lot of that help and not even think about it. So I do think it's really important as you're answering to think before you just answer automatically.
Yes, and that is a great reminder because I remember a situation where the assessment reflected that the individual could shower on their own, but the parent was standing outside of the shower, verbally guiding the individual of what they need to do, So it is true. There are a lot of nuances and thinking about the everyday and how much prompting it may take to help someone. Okay. Okay, so further strategies, examples of the documents. Again, what we've talked about, creating a list of those additional examples. Ginger and I just touched upon a couple of those. In the specific areas, when you are able to look at the answer sheet and see if they, again, were close, or even maybe the answers weren't reflected correctly for those substantial functional limitation categories, you may be able to meet that threshold by giving those examples. And it wasn't a yes, they can do it answer. It was, these are all the things, all the prompting, and all the help that they need to do it. So it gives a fuller picture. Consider which professionals could help when you gather evidence. There are some examples here: therapists, psychologists, teachers. If part of the struggle and the unmet need that the child has is behavioral, there's not risk assessment, there is danger to self or others. There could be a teacher that has witnessed this. They could do an affidavit. Same with relatives. So you can really gather some evidence that further illustrates what the concerns are, and help the board to understand the real circumstances for the individual. So once you've looked over the answer sheet, the user guides, the notes, gathered evidence, you could ask the county board for reconsideration of the assessment with additional documentation. And you can also ask for the assessment to be given again. And the third is going through the formal process. As far as what route you would take is really dependent on the circumstances. If you feel like with additional documentation, the assessment, say, found two substantial functional limitation categories and very close on the third, with that additional documentation, that would put you over the edge to getting eligibility. So maybe you want to ask for a reconsideration. If there were concerns about the execution of the OEDI assessment, maybe you want to ask for a new assessment. And you also do have the ability to go through the formal appeal process with the board, and we'll give more information on that.
I'm just popping in with a quick question from the Q&A if that's okay, before I
Okay.
skip to the next slide. I think this actually might be from the slide before. But they said I would like to clarify the criteria for substantial functional limitations as defined by the COED. So COEDI, the tools instructions specify that if a task requires assistance to be completed, it should be marked as no rather than completed with support. By marking these as functional with assistance, the assessment is underrepresenting the child's actual needs and the level of intervention required for daily living.
Yeah, each of these categories have specific questions, and they kind of weight them a little different. So sometimes you have to have 2 out of 3 in order to get the
Yeah.
yes, you have a substantial functional limitation. Sometimes it's like the opposite. So that's why it's really important to look at the assessment, because it can be a little confusing. And what that looks like is kind of supposed to be determined by the assessor. And that's why we're kind of telling you to put all that information out there, say it at the assessment. You can follow up after the assessment with written documents if you'd like. I love written documents. They make me very happy. Put it in writing, put it in writing, put it in writing, because you've always got to be thinking about the next step. If you're going to have to appeal it, you actually have a document that you have given to the county board and said, hey, I didn't realize, I told you about this and you didn't write it down, or, I didn't think about this, so I wanted to share some additional information with you and have you reconsider it. The things that Shannon talked about is that you have reconsideration. You can file a grievance appeal. Now they call it complaint appeal through the county board. It's a new role, and so this is not a Medicaid at this point, so it's not a state hearing. It is the process through the county board, and they have did give you a link to the rule, I believe, so you should have the new
Mhm.
rule. You can ask for reconsideration and still file a formal grievance.
Mhm.
You can do all of those things kind of at the same time. The rule itself does talk about if you do the informal or try to resolve it with them, you can agree to a different timeline, and you can do that, but make sure you get everything in writing, because you don't want to miss your opportunity to go through that appeal process if you need to do that. I kind of do it all at the same time when I get these cases, as long as I have time to do it. I will tell people, I will help them put together a document and just list examples. This happened, in the different category areas that you're trying to focus on refuting. And give as many examples as you can, give as much documentation as you can, and ask them to reconsider it. But you still could go through the process of appealing too. You have a period of time, and I always have to look and remember how many days you get for this particular process. But you can do some of these at the same time. But how they're defined is kind of what the assessors are supposed to do. But it's all based on that tool. So I'd say look at the tool, look at the guidance, get a sense from all of that what they should be asking, what they should be looking at, and then really just make sure you give as much information as you can to the county board to support these functional limitations that you see. Because and put it in writing, because you're going to need it in writing if you're going to appeal it. So
Thank you, Ginger. I
does that
appreciate
answer
it.
the question
I think so.
indirectly?
I don't see any more Q&As. Oh, wait. I was gonna say. Uh nope, no more. I was gonna say that answered the question, so thank you. And
Good.
I guess there is a new user guide that started being used as of December 2025. But the website is not, it's not on the new website that they're trying to make
Oh.
accessible. But you can reach out to the Department of Developmental Disabilities for the newer user guide at an email that I will put in the chat. It is waiverpolicyta@dodd.ohio.
I haven't seen that yet, so that's interesting.
I
I
know.
will I will
Yes.
tell you that the using the guidance documents in your hearing is really, really good. We took a case up through the whole long process getting up to DODD, and the decision at DODD basically listed all the stuff that we had mentioned in that was in the best practices, the guide, and basically said, yeah, you didn't do that, you didn't do that, you didn't do that, and sent it back. And ultimately, we got the person eligible. But it is a little bit of work. I mean, you do have to do a little bit of documentation, make sure that you are getting all that before the county board, so that by the time it gets up to there, they'll be like, oh, you got a lot of evidence here, and it is important to do that. So.
Well, thank you, thank you. Are we on the next slide now?
I think we are. Let me see here. Were we?
Got
Yes.
myself a little mixed up. I'm sorry.
Yes. No, 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 no. We sure.
Thank
And yes,
you.
thank you, Ginger, for clarifying that you don't just have to take one avenue. You can pursue the complaint with the county board, but also perhaps work it out with them before. So here is the rule. And there is a 90-day deadline for the appeal. And this is what I mentioned earlier, getting the denial in writing for county board eligibility, because that's when the clock starts ticking. And it's from the date on the letter, and it is calendar days. So you just want to make sure that you stay within that. And we have the rule up there for you as well. And also, you can reach out to us about anything that we're talking about today, and we can help assess the documentation, form arguments through the process. So if you go for county board eligibility and you get it, and you find that the services are not meeting all the needs, you can ask the county board for a developmental disability Medicaid waiver. They do also manage that process in Ohio. Individuals do need to meet the developmental disability level of care, and they have the right to choose going into an intermediate care facility or home and community-based service waivers. The goal of the system is to have community integration whenever possible. And the waivers that we'll talk about are for home and community-based services. So you can ask the county board to that you would like to have an assessment given for unmet needs, and the Ohio Department of Developmental Disabilities oversees this process in Ohio. And again, each county board implements the process in their county for the waivers. So there are three types of developmental disability waivers. There's the individual options waiver, the level 1 waiver, and the self waiver. And we gave links for these because you can look within the links and see what services are available that may meet an individual's needs within each waiver. And we also put a link for, there were some changes made in January regarding assistive technology and remote support. So that is there as well. So unfortunately, the number of waiver funding and the need for waivers do not match up. So there's a great demand for waivers, and there is a waiting list for this. So in 2025, the rule changed, it was updated. So we have a link to that as well for the waiver waiting list. So again, if you feel that you have county board services are not meeting needs, And that's what's nice also, going back to the previous slide with the waiver links. You can look in those and see what services are available and see if that's something that would meet an individual's need. And you can ask the county board for the waiver waiting list assessment. And they should use that assessment tool when when a family identifies an unmet need and asks for waiver services. So, what the waiver waiting list is really assessing is, does someone have a need or needs, and how urgent are those needs? And we also included frequently asked questions link that can be really helpful to give more information. So, again, looking for unmet needs. An immediate unmet need is something that is considered that it needs addressed within 30 days to keep the individual safe. Current unmet need is something that needs to be addressed within the next 12 months. Um, Unfortunately, there can be, if you are put on the waiting list, it could be for a longer time than that. So, county boards will use the waiting list assessment tool to determine if a person has a developmental disability, if they have an immediate need, a current need, or no needs on the assessment, or if the person is found to have a need, immediate or current, what services would address those unmet needs. And I think this is when I'm turning it over to Ginger.
Thank you for reminding me that. I was like, what's
Yes.
coming? I know, I wasn't sure which one. Okay. Okay, so once this assessment is done, they're basically, as Shannon said, they're going to decide the person has immediate need. They need services in 30 days. They have to do something to meet that need. That does not necessarily mean they give you a waiver. It means that they have to address that immediate need. If they determine that you have a current need and you should go on a waiting list, then they would put you on the waiting list. They could give you a waiver. I mean, they could just give a waiver to the person. Yeah, we see that this person has significant needs. We have a waiver. We're going to give you one. They could say, well, they have these needs, but these needs can be met by what's called alternative community resources. We're going to talk a little bit about that because that's the big thing we hear an awful lot about right now. So, it's not unmet. Well, it's unmet, but you can meet it by using community resources already available without a waiver. And so that's an area we see a lot about, and we'll talk a little bit about that in a minute. The sorry part about this whole assessment is that if you aren't found to have immediate or current needs, then you might not be entitled to anything from the county board unless it's something the county board provides through their own funding. And there are things you can get with county board services that don't come from a waiver. They have family resource money, they have respite services. There's a lot of different things county boards can provide out of their own funding, their local funding. You don't necessarily have an entitlement to it unless they agree to give it to you and it's on a plan. So it's not quite the same as a waiver. Once you have a waiver and everything on the waiver, your person would have entitlement to that. So, but there are services you can get through the county board. You can get case management. So having the SSA, services support administrator, who can kind of tell you, hey, you get these services over here. Here we can help you get services like that in this other agency. So those things can be valuable too. But if you obviously think that your person, your child, your adult with developmental disability needs more than that, and then if you are denied a spot on the waiting list, or you're denied a waiver, or any other thing that you did not get the Medicaid service you asked for, then you have a right to a state hearing. So let's go to the next one. So yeah, so basically, if a county board says, and we'll talk a little bit about this, they've done the assessment, they say, hey, you do have needs, we agree, you got needs, they're unmet, but you can get them met. They're supposed to give you a list of these community alternative resources, and they're supposed to give you contact information. You can also ask for them to help you reach out to those places and get those services. Lots of times people get very frustrated when they see the services. We get frustrated sometimes when we see what they're recommending to people. We've had county boards, we've seen several times now, county boards saying, well, we'll help you get into an ICF as an alternative community services, which is very, very wrong, because ICF, intermediate care facilities, are not actually community-based services. Those are institutional services. And that is not alternative community services. So we see a lot of county boards kind of giving people a big long list. You can go here, you can go here, you can do this as an alternative services. And there sometimes they are allowed to do that, and sometimes they are recommending things that they should not be doing. So if you have questions about those kind of things, you get something that seems unusual when you get your alternative community resources argument back in denial, you certainly can give us a call, and we can kind of talk through some of those things with you about how you can respond to that. But basically, if they say you don't have immediate or current need, you may not get anything at that time. The good thing is you can always come back to the county board as new things happen, new assessment, ask for new assessment, and go through the process again. But it is very frustrating for people. It's not an easy process. So, okay, we can go ahead to the next one. Okay, so this is an example that Dodd gives. And as I said, the county boards, we're seeing a lot of people being told, well, you have to go get a private foundation grant before we'll give you a waiver. Or you have to go to a higher rise and try services through them before you can get a waiver. Those are not correct statements. So there are some things that the county board or DODD is saying that county boards can do. So if what your child needs is to go to camp in the summer, to have a special needs camp, it's okay for them to go, hey, Family Children First Council will pay for camp. We want you to apply for that first before we would have to pay for that. If you needed to go to the Bureau of CMH for medical, because they'll pay for some services for people and it fits within the services that your child needs, they can tell you, hey, check this out and try that. Getting something from Job and Family Service for daycare providers. So they've given some, if your child has Medicaid, there are things you can get on straight Medicaid. So you can get a speech device, or you can get a wheelchair. So they may be able to refer you to your Medicaid, which is your insurance. And that's something that's probably okay for them to do. They should not be saying you have to go to a higher rise and get denied by them first, because you can actually have a higher rise and a waiver. So there are certain things we're seeing that county boards are doing that are, I think, a little overreaching and probably not appropriate. Definitely, if they're telling you they'll get you into your child into an ICF, because an ICF is basically would be saying that your child has the same level of need that a waiver is, and you get to choose which one of those you want to do. You don't get, they can't say, yeah, we'll do it if you want an ICF, but we're not going to look at a waiver. So there's things that people are being told, and we're seeing it in writing, so we know it's true. They are being told this by different county boards. So those are the times, if it doesn't seem right, I would say you would give us a call and we could take a look at it and kind of advise you on maybe how you want to handle that. But basically, if they give you a list and say, here, we've got all these wonderful services, you got to go try these things. What we're advising people is go call them up, find out what they have, because any community, alternative community resource has to be something that's actually available. So sometimes people get told, go do this, and they call and there are no services available in that county. And so then you have to document that. Hey, county board, you gave us this list. I went to all of them and none of these services are available, or they're not effective to meet my child's needs. You need to reconsider a waiver, because all the stuff you gave me, I went and looked at it. I tried to get it and I couldn't get it. And so we're asking for a waiver because my child still has, excuse me, unmet needs. So it's really common. We're getting a lot of these A lot of people are being told there are alternative community resources. So I say it's worth giving us a call if you have any concerns. But we definitely are telling people, go see. They may have services you could use. There's one, like if someone has Medicaid already, um, some people are able to get in-home health care services for straight Medicaid for their children because under Health Check, which has preventative care, they've been able to get services in the home even when they weren't able to get a waiver. So there are some things that it's worth looking into to see if it's something that your child could get, but it needs to be effective for your child and it needs to be available resource. And if you find they're not, then you want to document that and let the county board know that, hey, all these things you gave me, it's not going to meet my child's needs. They don't have them available. They have a 2-year waiting list, whatever you're told, document that and get it back to the county board and ask them to reassess it because all the things they told you that were available were not. So, or most of them, whatever. Okay. Next slide. As we said, some county boards are kind of putting really high standards on people saying, you have to go apply for a foundation grant, private foundation grant. You should not have to do that. So generally speaking, that's a no. You shouldn't have to go find every single other thing you could possibly do before you'll be able to get services through a waiver. So just if it seems like it's out of the realm, I would say give us a call, let us know. We can take a look at what's being recommended and kind of advise you how you might want to handle that. Because basically when they're saying alternative services are available, they're saying that you don't need a waiver because you have these services available without a waiver. So if you don't, we need to document that and make sure the county board's aware. And some county boards are really good about giving you some real things, and other people are just giving everybody the same list, and they kind of have to sort through and see whether they can get anything. And if not, let the county board know that that's not accurate. That's not correct. And if you do challenge the denial based on alternative resources, all these things you do to go check are things that you would share with the hearing officer. Hey, they told me I didn't, he wasn't eligible for a waiver because of these alternative resources. I called them and spoke to so-and-so. They have a 2-year waiting list. I called them. This wasn't available. I called them. This isn't going to meet his needs. They'll give him 1 hour a week of services and he actually needs 50 or something like that. So it is really important to follow through when you get these and document it. And it's not going to be a waste of time because if you end up doing a hearing, this is going to be stuff you're going to take to the hearing officer because they're saying you have these services and when you really don't have them, they're not effective. That's a good argument that your child needs a waiver. Okay, go ahead. Okay. So it used to be that we had a waiting list in Ohio that was everybody got put on the waiting list. My son was 4 when he went on the waiting list. He ended up getting at the top of the waiting list like when he was 20. So it wasn't a great waiting list system. It was really unworkable and people were not able to get what they need. So they created this new waiting list process, which is, it's got its problems too. But they wanted to make sure that everyone has the same process to go through across the state. So they've put in some timelines for how this process works. It used to be you'd call and you'd say, I want a waiver, and they'd be like, okay, we'll think about it. But there was never any timeline started. They just didn't do the assessment, or, some places would do them, other places were not. So, put your request for a waiting list assessment in writing. I'm going to say that 100 times throughout this whole presentation. Put it in writing because it starts your timelines. So they have 15 days once you request it to initiate it. They have 45 days to complete the interview. They can extend it. They have to let you know why. They have to have a good reason why they're extending it. And it may be that they need to get records and they weren't able to get them or whatever. There are reasons. But then after that time, after it's completed, they have another 10 days. So you're looking at about 70 days from start to request to finish that you should get something from the county board about a decision on the waiting list assessment. Okay, go to the next slide.
Thank you. And before I go to the next slide, I was just going to say there was not a question, but a comment that a lot of the alternatives that were listed will sometimes decline to provide services when the person with a disability has certain specific behaviors.
Yeah,
from their
for sure.
experience. Yeah.
And you just need to document that. Just document it. And, I tell people just go down the list, call everybody, get it documented. You can put who you talked to, what they told you. That is going to be helpful when you're coming back to the county board, and also if you're in a hearing, they're saying all these are available. They're not available to him because they won't take him because he has behaviors. But you have to document it. You can't just say it. You've got to follow through and see. And you might find some good services. I'm not saying there aren't good services on some of these lists. You might find something that actually will be helpful. But if you don't, then it gives you the opportunity to come back to the county board and go, nope, those are not available resources, or they're not going to be effective. Okay. So they have to give you a decision in writing when they do this assessment. They have a tool they use, and they are supposed to give you specific information about how they came to that conclusion. You have to be provided the completed waiting list tool and what you can do if you disagree, what's your due process. Because we're talking about a waiver, so even if you didn't have a waiver, but you've been denied a Medicaid waiver, that's a Medicaid service. So that all gets challenged through the state hearing process. And in Ohio Medicaid uses a job and family service process. They have a whole process, and they have a hearing officers who will look at the rules and see, will do the hearings basically. It can be sometimes very helpful because it's a more objective kind of process that maybe going through the county board process can be. So eligibility goes through the county board process, but the waivers, anything around a waiver service that's been denied or a Medicaid service, those go through state hearing process. If you don't get a copy of your completed waiting list tool, put your request in writing for it. You want to do these fairly quickly because you have a specific timeline that you need to make sure that you have time to get everything you need to prepare for a state hearing if you have to go there. They're supposed to be provided, again, very specific things about each need, each unmet need that was addressed, and give it. The ones I've seen, the tools, they've been pretty detailed. So, they do have a process, and it'll give you, I think, generally a good idea about how they made the decision. Now, you can also do kind of what Sharon talked to you before about the assessment. We can say, well, no, that's not quite correct. I told him this or whatever. So you can do some of that, but it also just gives you a real good sense of what they're going to argue in a hearing. So you can be prepared to address the opposite and say, no, that's not correct. And then they should, like I said, they should have given you contact information for the services to help you, to check out those other resources. And you can argue about some of the things if they didn't do a great job, but really, I think the focus is on what does your child need? And was the assessment correct? And what did they not address? And look at that kind of thing. But the community alternative resources is a big one. We also get we see a lot of county boards talking about natural supports. So when you're a parent of a child with a developmental disability, it does not mean that you can't get a waiver. Many people have waivers, that their children have waivers, even though they are children. But there's this conflicting aspect to this, is that when you have a child, you certainly have obligations to take care of your child just like anyone else, even if they have higher needs. And so you may get a little bit challenged on, well, you have to take care of your child. You're their natural support because you're a parent. However, there are children with pretty significant disabilities that, a parent cannot do all of that by themselves because the child has such high level needs. So there's always a little bit of tension there when it's a child. You will get sometimes the county board kind of like, sorry, that's your kid. You have to take care of them. So you kind of, instead of reacting to that emotionally, try to be very professional about it, focus on the child's needs, not that, this is really hard for me as a caregiver, even though it is, and I totally get that. But really keep it very kind of professional. This is about the child's needs. The child has not just normal needs, they have all these additional needs, and parents are not able to address all of those. They have to sleep, they have to go to the bathroom, they have to do, take care of other children. But you want to be really careful. We see a lot of problems when parents, and they're not wrong, they're trying to explain to the county board, well, I had to quit my job and I had to, I have 3 other children with special needs, and all of those can be important factors, but you have to be really careful when you're making an argument for a waiver that it has to be completely focused on the child's needs. So even though, of course, we all know all of that impacts everything, your family dynamics and all that, but be really careful how things are worded because we do see a lot of cases where people have, tried to be like, can I board? I can't work. Nobody will, there's no daycare that will take my child because they have behavior. And that's legitimate, but you really have to be, my child has so many needs that he needs, these additional services, and keep it on the focus on the child's needs more than maybe the caregiver. Sometimes the caregiver information, as you saw in some of the immediate and current need definitions, it is a factor, but be really careful how you present that because it tends to kind of veer off the issue, which really is, what does this child need and how are their needs not being met? And so, we do hear a little bit about natural supports when it's a parent and the child's, 3 or 4 or whatever, and they're living at home. And so anytime you have those kind of issues come up, I think it's probably would be worthwhile to give us a call. We can kind of talk to you about maybe how to present the arguments so that you're not getting caught up in that, well, you're the parent, you have to do that. We get that up quite a bit. And it is hard. It's a hard conversation, but I think there's a way to present things that can avoid those kind of problems when you're looking at waivers, if that makes sense. I don't know if anybody's had that issue, but we get a lot of calls about that. So we can go to the next one. So they have to tell you, you have a right to challenge it. If they put you on a waiting list and you're not happy about it, you can challenge it. If they deny you a waiting list placement, you can challenge that. If they take you off the waiting list, you can challenge that, and other things too. But anything that basically denies you a Medicaid service, then you have a right to a hearing usually, to be able to challenge it and say, no, I don't think that's correct. Okay. Next. Just kind of wanted to touch on some myths. As at DRO, we cover the whole state. So we see a lot of kind of these things happening across the state. So we kind of see trends. And so I just like to mention them here, a little bit. So some people have been told, oh, well, you have to apply for a home care waiver before you can, get a waiting list assessment. Not true. A home care waiver generally is for kids that have a lot of serious medical needs. And so you can be DD, but also get a home care waiver if it's a medical kind of situation usually. Because usually for DD waivers, you're not going to get the level of nursing you might get in a home care waiver. It really depends on your child's needs. So, but they shouldn't be telling you, oh, you got to go through that whole process and get denied before you can do this. They shouldn't be doing that. Again, they shouldn't be saying that, you have to apply for a high rise and get those services in first before you can get a waiver, because that's not correct. And then the other thing that's important is you do not have to be Medicaid eligible before you can ask for a waiver or go on the waiting list. Now, let me say this, Medicaid is based on financial eligibility, generally speaking. With a waiver, a child who has a waiver, even if their parents make more money than would make them eligible for Medicaid, they get Medicaid because they have a waiver. So it is a very good way for some families to get their child on Medicaid because Medicaid has extra services for children. But you don't have to be Medicaid eligible before you go on the waiting list. You will have to be eligible for the child will have to be eligible for Medicaid if they get a waiver. But what they do generally is look at the child's income, not the parents, which is big difference usually. I mean, there are some children I'm sure that have money, but generally speaking, it's the parents. And so it's a very valuable thing to have a waiver because then once you get Medicaid, then you have more services you have access to than you might have if you didn't have Medicaid. But you don't have to do that going in. You don't have to, they're not just going to say, we're only doing waiting list assessments for people that already have Medicaid. They shouldn't be doing that. Okay, next slide.
Yep, I will advance. I just want to let you know that it is 12:59 right now.
Okay, sorry.
No, you're fine. You're fine. You've got a couple
Well, let me speedily just say I put a bunch of information on the state hearing process. It's on our website. We have some actually very, very, very good materials on there. If you go on our website, you can just Google Disability Rights Ohio. We have a self-advocacy resource center. It'll pop up a bunch of boxes, and Medicaid is one of them. We have information on health check if you have Medicaid. Children have kind of more services they can get than adults under that because there's different standard for children. We have a discussion general overview of the state hearing process. We have kind of information of each stage, what the hearing officer will be looking for, and how you might want to present your claims as you go through the original state hearing, then administrative review, judicial review. So there's some really good information on there. It's pretty easy to find on our website. So, but basically that's that's kind of the process if you're denied any kind of Medicaid service, you go through a state hearing. So okay, there we go.
Do you want me to go through these slides really fast?
You can either do that. I mean, pretty much it was just talking about the state hearing process. So
And
I think
yeah, I was gonna say, and what will, I'm just gonna scroll through them. So if you see
okay.
anything you want to check on really quickly,
Um,
I will say that the presentation will be sent out to all the participants today. So anyone
good.
can look through these
Yeah.
and contact DRO if you have any more
Yeah,
questions.
absolutely, absolutely. And these are all just kind of the evidence how we would want you to try to look at how you're going to prove what they're saying you he doesn't meet the level. You're going to have to show at a hearing that they do. And so I don't think I think it's very individualized. So that might be one where you want to give us a call. We can certainly talk with people. We don't generally take people's hearings, although we have. But we generally walk people through the process and look at their facts and kind of give them advice on how they might want to present their arguments, how what kind of evidence they might want to try to get to challenge whatever the reason for their denial was. So
Awesome. Well, thank you so much. I'm sorry we weren't able to get to it today. We've only got so much time together, but I really appreciate all the
yep.
information, Ginger and Shannon, that you both gave today. I know I learned a lot and I'm looking forward to going through the rest of the presentation. I was sending links along in the chat box once I was able to figure out how to do that. But they are also available in the presentation, which will be sent out to everyone. Again, you can go to our website, lawyersforstudents.com/legal clinic to sign up for next month's, which is by Danielle Randolph and all about interpreting ETR results to be able to apply it for the IEP. Shannon, Ginger, do you have anything else for us?
Nope.
No,
All
we
right,
were
thank you.
happy to be here today. Thank you.
Yes,
Appreciate
yes,
it.
very happy to have you here. Thank you both so much. We really appreciate it, and I hope everyone has a great rest of their week.
Thank
Thanks,
you.
Shannon. Thanks, Ginger.
Take care.
Absolutely. Bye.
Take care. Bye bye.